talking on managing commercial conflict. It's a subject which is very dear and close to my heart. And what I'd like to do is to start by sharing with you my background, then to spend some time looking at managing conflict in both the forming of commercial relationships and during the execution of a commercial arrangement. Then let's turn to look at the options for resolving disputes, and finally the tangible differentiators which I believe mediation offers. I've worked in the world of commercial disputes for over 30 years, having trained as a commercial litigation solicitor. But it wasn't long before I realized that the solutions and services which I offered were very much a distress purchase. It generally meant that something had gone wrong in somebody's business or working life, which needed to be resolved. So I decided to broaden my focus. I sought to apply my knowledge and experience, not only in solving the problems, but to assist businesses in their development strategies and their management processes. I wanted to learn what success looked like to each of them, hear what was keeping them awake at night, and understand their pinch points in terms of risk. And then in doing so, I could then enable those businesses to maximize the opportunities whilst minimizing the risk of conflict. That felt very natural to me as it aligned with my own sense of purpose as a human being, and that being to help others to thrive and to be the best versions of themselves. I've had a long-held view that prevention of any potential conflict is in all likelihood preferable to businesses rather than the need to cure it. A bit like the doctor, prevention is better than cure. If we can limit the level and frequency of disagreements and disputes, then that would aid commercial clients to focus on their core business without any unnecessary distraction which disputes and litigation necessarily entail. In 2012, I became an accredited commercial mediator, and I shall talk about that a little later on in this talk. But in 2015, I was appointed the managing partner of Paris Smith, which, for those of you who don't know the name, is, as Will has said, a regional law firm in the south of England, based in Hampshire. It's very clear in its core purpose to enable client success and our communities to thrive. And you'll see that there's a strong alignment with my own personal sense of purpose. The firm has grown at a consistent rate to the start of the pandemic of 9% a year over the past 6 years, and we now muster 255 people. Enough of the firm. Disagreements, disputes, conflicts are a fact of life. I recall that when I was about to get married, my late father said to me, "You and Vicky, my wife-to-be, will not agree on everything, but you will be able to find solutions by talking through those differences." And indeed, so it has proved 32 years on. The commercial world and business relationships are not immune to disagreements. One only has to read the newspapers to see the issues which arise between organizations, some of which are entrenched, but many of which are skirmishes quite capable of resolution if the appropriate tactics are adopted. The pandemic has given us an opportunity to consider what sort of world we want to live in for the future. Many have talked about the need to adjust to a low-touch digital-driven economy. One sees businesses across the land reviewing their sense of purpose. Many are pivoting their business model to reflect the changing consumer behaviors. And the growth in e-commerce has been building over past years, but it has now been supercharged by COVID-19. Equally, businesses are resetting what success looks like for the future. In the past, the sole pillar or measure of success was profit. Now, in my view, there are 3 pillars: people, planet, and profit. The people element, how one impacts people, the contribution to the environment and the communities, in which we live and work, and finally profit to reward endeavours, risks taken, but importantly, to fund future investment. And with this in mind, conflict management comes to the fore as businesses seek to negotiate the commercial arrangements against the backdrop of purpose, revised or otherwise, and these three new pillars of success. Let us not forget that behind every commercial deal is a mix of individuals who will each have their own needs, wishes, and obligations. In the main, they will be accountable to others when undertaking any form of negotiation. The commercial director will answer to the CEO to the chair to the funders, shareholders, or other stakeholders. In the world of charities, the leadership team will be accountable to trustees, who in turn will be answerable to the Charities Commission and those who may be supporting the charitable endeavours financially. In the public sector, the local authority are accountable to the electorate, and there are checks and balances with national stakeholders, as we know. In the home environment, many of us are answerable to our partners, and for me, I am answerable to Vicky, my wife, in no small measure. Negotiation is part of life, and I found that one of the keys to successful negotiation is to understand the needs and desires of the individual people with whom you are dealing. What do they need to achieve to fulfill their obligations to those to whom they report? In essence, what will make them look good in terms of their paymasters and help them sleep easy at night? Creating a win-win outcome in which you get what you want to move forward, but also for the other party to do so as well, will build trust and confidence. In doing so, the chemical oxytocin will then be released within each party to the negotiation. That helps one feel positive and upbeat, a formula and foundation for long-term relationships, an opportunity to build reputation as being an honest and good organisation with whom to do business. This doesn't mean that you have to open the full box of goodies for them to take their pick, or to show that you've rolled over, let them tickle your tummy in the face of every request that they make. No, of course not. You have your own responsibilities. It's your business for which you are responsible, which you need to lead, to protect, and to develop. But the heart of negotiation is clearly communication. Explain why you need to take certain positions, why you have the red lines in negotiation which you have. This will help your fellow negotiator understand your position and help them to explain it to his or her superiors without losing face or appearing to have failed. And if you have an impasse in the negotiations, take some time out. Breathe, reflect, go for a walk, and think whether there is another way to overcome the hurdle which you both face. Consider suggesting to the other party that you both reach out to a trusted independent party who might look at the position from afresh, someone who may be able to facilitate the negotiation from a different perspective, but with the same outcomes for you both in mind. Now, I believe more than ever, the notion we need to do it that way because that way is the way that we have always done it no longer holds good. So let's now move to the resolution of disputes where conflict is such that the relationship has broken down or is at serious risk of doing so. When I started out in commercial litigation those 30 years ago, and for many years thereafter, the manner in which disputes were resolved was simply through the courts, or rather that was the legitimate way to do so. I'm aware that there may have been other tactics or forums which no lawyer could possibly condone. But over recent years, and in particular the past 10 years, there have been a significant developments in commercial conflict management. These have not only been embraced by the courts, but actively encouraged, as we shall see shortly. we have a plethora of different forums to resolve disputes. There's been a fundamental shift developing. Conflict management has become and is an increasingly important part of corporate governance. How businesses deal with conflict will impact on how they are perceived in the marketplace, their attractiveness for an investor, acquirer, or commercial partner. Businesses want to deal with businesses with whom they can have a relationship built on trust and shared values. Quite simply, it is part of managing business risk. And at this time, during the pandemic, business risk has certainly come to the fore. The world of social media can quickly identify those who deal with conflicts badly, but also those who work collaboratively to achieve a solution. So running quickly through the different forums for dispute resolution that we have, in addition to the courts, there's commercial adjudication, which may be suitable for businesses in the public sector in disputes that require a binding decision from a qualified neutral in circumstances where resolving the issues by means of arbitration or litigation is considered to be either too slow or too expensive. It can be used for contractual disputes of many kinds and where the issues are narrow and the documentation the adjudicator is required to absorb is concise. Construction adjudication was developed to allow for construction contract disputes to be resolved on an interim basis more quickly and cost effectively than, again, through arbitration or litigation. Usual circumstances are that adjudicators have to render their decision within 28 days of an appointment. Arbitration, a confidential process, so not open to public view, in which independent third parties are appointed to decide the outcome of a dispute between two or more parties in accordance with set rules of arbitration. The arbitration award is final and binding, and often used where parties require that confidential process or where an arbitral award may be more easily enforced than a judgment from a foreign court. Increasingly, we're seeing early neutral evaluation, which is designed to serve as a basis for further and fuller negotiations, or at the very least, help parties to avoid unnecessary stages in litigation. Normally non-binding, and used as a guide as to how a court might interpret a document, a set of facts or evidence, and a guide as to an outcome that one might expect from a court. Frequently, I've seen this in family litigation, but also in engineering disputes, insurance disputes, rent reviews, and similar types of disagreement. And finally, expert determination, which is particularly suited to disputes of valuation or those of a purely technical nature across a range of sectors. Generally, the decision is binding unless it is agreed otherwise by the parties. It can be a very shortcut method to securing a binding decision. No requirement to prepare pleadings, conduct detailed investigations, cross-examine witnesses, but is often useful as in conjunction with other dispute resolution processes, and can be used as an adjunct to mediation to give a binding decision on an important issue. Expert determination provides the parties with a means for resolving a part of dispute which they would prefer not to have to negotiate. And it can also help to break an impasse and allow a mediation to proceed without that blockage, and enabling the mediator to remain completely impartial. Each of these forums has a role in helping to achieve settlements to commercial disputes. And as you've seen, there are a number of forums available. And clearly the forum to choose will depend on the nature of the dispute, the issue, the complexity, need for privacy, and importantly, the ability of the other party to pay, amongst other aspects. But we mustn't forget the court process. Court process has stood the test of time and is still robust. It is a tried and tested forum for determining disputes. But the downside is the costs of litigation are not to be underestimated. They can be significant. The court fee alone for some disputes can be eye-watering. If you have a dispute where the value is more than £200,000, or for an unlimited sum, the fee simply to issue the claim form in the court and get a court stamp on it is £10,000. That's the fee that's paid to the court service, doesn't include any lawyer's fees in producing the document or the for work undertaken prior or post the issue of the claim form in assessing the merits of the claim. So litigation shouldn't be entered into lightly and needs careful consideration. Some questions to consider in addition to assessing the merits: does the value of the claim justify the costs that would be incurred, the financial and the management time? Does the opponent have the means to pay which you are claiming in addition to the costs which you might be awarded in the event of us being successful? Do remember that if you secure a judgment, that is only half the task. Securing payment of that judgment is the completer and finisher of the exercise. Also remember the general rule that you will be able to recover only about 70% of your legal costs if you win. And in a long-running complex case, those unrecovered costs can be significant. Seldom is there a case in which a lawyer would say that's a slam dunk winner. The best you will get is a case which a lawyer will say there is a strong chance of success, and I know that the lawyers on the call would agree with that. So let's turn to mediation, and let's look why mediation offers something different to these forums and why it is so relevant today. Lord Neuberger, speaking on the Today programme earlier this year, commented that there will be a build-up of disputes in the world of business as a result of COVID. I agree with him, not from the position of a commercial litigation lawyer, but from what I see and hear in my business dealings generally. There is a vast array of business issues which are coming to the fore that need to be resolved, whether it be staff returning to the workplace and feeling anxious about doing so, flexibility of working arrangements in the long term, the relationship between commercial landlords and tenants, particularly on the high street. In that regard, some are suggesting that rent should be more geared to turnover or footfall. There are also tensions in supply chains as to the speed at which money is changing hands. Payment of invoices and bills are being delayed. All these issues need delicate handling to preserve key relationships. With these new issues, there's an opportunity to find solutions by collaborative approach rather than a confrontational one. During the pandemic, I've seen and witnessed a willingness to collaborate, to share learnings and experiences. That's even so amongst competitors, learning and supporting each other, working together for a common goal. Without doing more than dipping my toe into politics this morning, one can see and feel the difference in approach between the two candidates in the recent US presidential election. One clearly had a more collaborative approach than the other. And in terms of business, collaboration will rise in its importance. I frequently recite the acronym TEAM. Together, everyone achieves more. So let's look at mediation and its benefits. First and foremost, the parties have control over what settlement is agreed. Neither of them, assuming there are just two parties to the mediation, are committed to a settlement unless and until it is formalized in a signed written agreement. It's confidential and without prejudice to any dispute resolution activities which may be taking place in another forum, such as the court. It ensures the parties can be open and honest, safe in the knowledge that what is said in the room stays in the room. and won't be used elsewhere except for very exceptional circumstances. It provides a foundation to explore the options for solutions, understand the strengths of one's own position, but also its weaknesses, strength and resolve of the other party and their needs, which may not have been apparent until that moment. As we know, much can be missed and misinterpreted in emails and legal communications. Mediations often be described like buying a car. You may test drive a number before choosing your preferred one. During mediation, a number of settlement options may be offered. It's for the parties to consider which is the best for them. Worth bearing in mind that you're not committed to a settlement until it's formalized in a signed written agreement. Nothing is binding on either party until those terms of a written settlement agreement are both agreed and signed. It's been known for a verbal agreement to be reached, but for one of the parties just to celebrate a little too early before the document is signed and sealed. In the one case that I heard of, a party celebrated with some alcoholic beverage before the written agreement, and in that instance, neither party could sign the agreement until the following day, when the party that had imbibed a little too much had sobered up, was in a fit state to understand the terms of the agreement to which he had committed. Mediation affords the ability to look forward rather than solely make judgments on the past, and I think this is the crux of mediation and why it is so advantageous. Courts can and do make judgments and decisions on what has happened, who was at fault for the breakdown of a relationship, for the losses caused, the harm done. It looks to recompense the aggrieved party, usually by way of financial award known as damages. But conversely, settlements agreed in mediations can take account of what has caused the dispute or disagreement, but also to reflect what the party's own interests are for the future. Let's take the example of a dispute whether a supplier with whom you want to continue to trade and indeed need to trade together for the future. The adversarial nature of litigation may make that dispute impossible to continue to maintain a relationship for years to come. But a negotiated settlement in mediation can preserve the relationship on agreed terms and in a way that will work for both parties for the future. Mediation enables the parties to propose and agree settlement terms which are much wider than those available to a judge or arbitrator. It can provide outcomes which a court could not order. And in our example, it could include a variation of the existing commercial agreement or an establishment of a new one. Mediation is undoubtedly quicker and cheaper than other forms of settlement of disputes, such as court litigation or arbitration. And even if the settlement is not reached then, it frequently has the effect of narrowing the issues or for the parties to get a better understanding of each other's position and the merits of each side's case. In doing so, whilst the settlement may not be agreed at the mediation, the parties are drawn closer, and often a settlement can be agreed in the following weeks or days. Statistics confirm mediations have strong prospects of success. They don't lie. Statistics in 2018 confirmed that mediations have a success rate of 89%. Yes, 89%. 74% achieving settlement on the day of mediation, and 15% shortly after mediation. Those are staggering statistics, and if there is any doubt that mediation is effective, I think those statistics prove the worth of mediation in resolving disputes and managing commercial conflict. So I'd like to end with some tips which have arisen from questions that I've been asked over the years on mediation. So number one, top tip one, What preparation can I make before a mediation? Take time prior to the mediation to seek to recognize and understand the needs of the other party. Put yourself in their shoes. What do they want the future to look like for their business? But equally, what are your priorities? So important as we now embrace the new pillars of success that I talked about and that spirit of collaboration. Tip 2, understanding the other party's strategy and how does that fit into your own long-term goals. Think about their strategy. Are they looking for a solution that works for them as well as for you? Do they want to avoid litigation? Or are they coming from the mindset where they are intent on hurting you and feeling like the victor and you the loser? Do they come from a position where they can't be seen to lose? We know a certain world leader who does not like to be seen to lose, and there are businesses who fall into the same context. Is it a relationship that you would value in the new world? And consider adjusting your negotiating style to take account of your answers to these questions. Third question and tip, is mediation a sign of weakness? Certainly not. Don't ever think that offering or agreeing to mediation is a sign of weakness. Indeed, the courts expect parties to explore mediation before bringing a case before the court and provide an opportunity for open and honest discussion. The courts go further than that. They can and will impose sanctions if litigation comes before them and a party has either refused to mediate or ignored a reasonable request to mediate. Tip 4, should I make the first offer? Some have suggested that making the first offer is a mistake and could be seen as a sign of weakness. In my view, it's not. It sets a line in the sand and you can expect the other party to do likewise. You then have the parameters within which a resolution is going to fall. It will fall somewhere between those two tram lines. By making that first offer, you have simply put the mark down in the sand as to where your tram line stands. And finally, tip 5, what does a successful mediation look like and feel like? Parties to a mediation have often expressed a sense of relief that the dispute is over. I've seen some share a bottle of champagne that they've been able to settle their differences in a day, a concept which might have been unimaginable at the start of that day. For an experienced mediator, a successful mediation is one in which the parties finding the solution have an outcome with which they can each live, but neither is overjoyed. In doing so, you have found the middle ground to enable them to move forward. So thank you very much indeed for listening to this talk. I hope you found it useful and valuable.